Thank you very much for joining us. I know it's a rainy, miserable old night, and we're going to have a few more of these to come. But we shall be talking about something far more exciting than that today. We've got Rebecca Chadwick from our latest legal partner. I want to say Landlord Support. I was going to say Landlord Solutions then, but it's Landlord Support, right?
It is. It's actually full. If you want to full name, was Landlord Support Legal Solutions.
Where I mixed it up then. I
There
knew
you
there was a
go.
solutions in there somewhere. Um, Having come aboard only 2 or 3 weeks ago, I think we did an official launch. What we want to get into today is more the contentious side of the kind of legal bubble that us landlords need to be living in. We're not going to be talking about conveyancing. We're going to be talking a little bit more about your requirements as landlords, what you need to do, and what you need to do if you get yourself into a little bit of trouble as well, because we know that, as with all things property, it's not always smooth sailing, unfortunately. So I shall be your captain tonight. My name is Anthony Bailey-Grice. I'm the managing director of LMPG. Behind the scenes, down in the wherever the chefs go in the boat, we've got Laura cooking away, who told me specifically she does not want to be doing the introduction, has left it to me, but she has cooked up all of this webinar, onboarded landlord support, all the rest of it. So really, she's the one that should be talking right now. I'll take the credit. And of course, Rebecca Chadwick from Landlord Support. So before we get started, I'm just going to do a little bit of hygiene here. So we do have a chat function, which you can find at the bottom of your screens. I'm just going to type something right here. If you've got a question as we're going through tonight, do pop it in there. Myself and Laura will be monitoring that throughout the night. If it's something particularly pertinent to the subject at hand, we will ask that question if it's for clarification or whatever it might be. If it's a bit more of a generic question or something that we think, okay, that's going to open more of a discussion, we'll save that to the end and do a bit more of a Q&A toward the end. This session is being recorded, I hope. Is it being recorded? It is being recorded. Thank goodness for that. Because we're going to be sharing this after the fact. So just a warning, if you don't want to be in the recording, anonymize your name, turn off your camera, all the rest of it. If you don't mind being the recording, then you're going to be sitting on the LMPG website from now until, well, however long LMPG's in business, the next few decades at least, for sure. So a little bit of a warning for you there. But without further ado, Rebecca, are you ready to go?
I am ready to go, and I even clicked on mute. We're not going to talk about how I forgot about my camera earlier. I've just said that on the recording, haven't I?
You're the one that brought it up.
I know.
I would have trimmed the beginning off.
Yeah. Well, it's in there. It's in there. I don't know how to do computers, but I do know how to do law, and I do know how to share my screen. So, without further ado, it says I'm sharing. Can everybody see that?
It's all good.
That's there. Wonderful. Okay. Very quickly, introductions, because they can go on forever, but I don't intend to, because there's so much law that we could potentially pack into this, that I want to get straight into the nitty-gritty. So just very quickly, there's me. I'm head of legal at Landlord Support. There's our head of commercial, Josh. Yes, we have the same surname because we are married. We've actually been married longer than I've been a solicitor, so you can work that out there. I've been a solicitor now for just over 14 years, but I've actually worked in tenancy management for longer than that because I got through into it as a clerk and as a paralegal. So I've been doing this a long time. I've also done this kind of work with local authorities, with council housing, with social housing, the registered providers, and predominantly with you guys, the private guys. And Landlord Support's been around since 2020. So who is Landlord Support? We were created for landlords. So we specialise in residential tenancies. It's all we do. We only work for landlords. And as Anthony said earlier, contentious issues, that's what we do. Again, for the recording, I avoided conveyancing like the plague when I was training. It's just so dull. I'm really sad. I quite enjoy the contentious aspects of landlord law. We're called Legal Solutions because we want to be practical and we want to solve things. So it's not just about getting into court and seeing a judge. It's about how can we work through situations to get the right outcome for everybody. And very helpfully, we have a fixed fee structure, so you know what you're paying. but we will be providing high quality service because we're qualified solicitors, long served in this area of the law, but we genuinely don't cost the earth. And just very quickly on this next slide, you'll see our standard pricing structure is on the left, and the LNPG special prices that you member guys get is on the right. So you'll see that you are actually also getting a discount there as well. So they're on there. I'm not going to dwell on that. If you need anything, you can obviously get in touch with Anthony or Laura, or our details are on here. You can come to us as well if you do need to find out more on going forward, any prices. So you're a landlord. So what? Well, I guess having done this for so long and having seen it so often, it's really easy for a landlord to mismanage the tenancy, whether they mean to, whether it's by accident, whether it's by ignorance, omission, whatever it is. But you put yourself at risk, you put your property at risk, and you put your profits at risk if you're not doing it right. And so we want to make sure that you are set up to do it right. And so what this session is about is giving an overview and an awareness of what your legal duties are, what the processes are, to make sure that you're properly, lawfully and successfully managing your tenancies. And I say successful because they can be successful. There's lots of landlords I don't speak to because they're doing a good job. There's a lot of landlords I speak to who just need a little bit of help and then go on to do a good job. But generally speaking, a lot of the landlords I'm speaking to either aren't sure what they're doing or have done it wrong. So I sincerely say this, I always say this, that I hope that you don't need us, but if you do, we think of ourselves as that unspoken of emergency service. When something goes wrong, you can get in touch with us and we can help you through it. So this isn't supposed to be a scary slide, but it doesn't look the best, does it? But you're probably aware, and some of you I will maybe be teaching to suck eggs because you'll know an awful lot of this. But I think quite often just talking about things and rethinking about things, you might pick up little nuggets, little gems that you weren't aware of, or your memory might be refreshed of something. But there's a big list here, 2, 4, 6, 8. There's 8 there, legal obligations. That is a generic list. That is not talking about the Landlord and Tenant Act 85 or the Housing Act 2004 or the Gas Safety Installation and Use Regulations 98. These aren't the actual laws per se, apart from potentially the top one, which is about disrepair, you may know. But this is just a list of the kind of obligations that you have on yourself as a landlord, such as in relation to licensing or in relation to the right to rent requirements, your deposits, etc. So there's loads of legal obligations. You'll probably be aware of most of them. There's sometimes little nuggets in there that you might not be aware of, which may never trip you up anyway, and it might not matter. But we're here just to make sure that you're not tripping up on anything. So if those are your legal obligations, I think the first thing to start with is what the law actually says. And so residential tenancies have special protection under the law. They're treated very differently, first of all, to commercial tenancies. We don't touch commercial tenancies. I did way back when. It's just completely different plethora of laws. So they are so different. And if you read the media, if you listen to the news, etc., you may well have the opinion, as do I 9 times out of 10, that residential tenancies are very tenant friendly, and the law seems to be drafted in that way and works out in that way. And I guess the main thing to think about is what the law says. And this isn't written down in an act. This isn't in the Housing Act 88 or 2004 or the Landlord and Property Act, etc. This is a common law principle. So it's accepted that the tenant has a right to quiet enjoyment of the property. So what does quiet enjoyment mean on a practical level? It means that the tenant occupying the property can only be interfered with by yourself as a landlord through a lawful procedure. So it's their home. It's your bricks and mortar, but it's their home. And so on a practical level, they're entitled to quiet enjoyment of that property, their home. And we'll come back to that because this kind of underlies a lot of the legal basis of how we conduct ourselves as landlords. So what I want to do is go through it step by step. I think just before I jump into it, Anthony and Laura, I guess you guys will just, as and when, if you see something in the chat, you'll just kind of put your hand up and I'll stop, or however you want to do that.
Absolutely, I'm not shy about interrupting, Shalini.
That's
So I've
fine.
drafted a couple of questions as you've gone through already,
Okay.
actually, but I'll leave them for the time being.
Okay, wonderful. Yeah, because otherwise I'll plow on and it, you know, it's struggling then to try and get back to it. So that's fine. Just absolutely jump in. What I'm going to do is walk us through the steps and discuss the pertinent points that come up in these steps. Now, we don't have a long time, so we cannot go through everything with a fine-tooth comb. I'm picking out the main bits, and maybe just digging into those a little bit more. So first things first, before we start, there's no answer on this slide. I just want you to think about this question: who has the legal right to end a residential tenancy? So just have what you think the answer is to that in the back of your head as we start to go through this. I am going to give the answer because it, again, the answer to this question again underpins how we conduct ourselves. But just have a think about who is it that can bring this tenancy to an end. So new tenancy starts. First things first, what type of tenancy agreement? That's a misleading question because it might not be a tenancy agreement. It might be a lodger style situation. So you've got a license, or it might be a straightforward tenancy situation, assured short hold at the time. For now, we're on assured short hold. We can come on to that. If it's a rent to rent situation, it can't be an assured tenancy. So first of all, as you're setting up this new tenancy, what is it? And then the next question you need to think about is, do you actually have the legal authority to offer it? So of course, if it's an HMO, have you got the relevant license? If it's in a selective licensing area, again, have you got that in place? Think also about if it is some kind of rent to rent situation, you know, are you the freehold owner that is going to be the head landlord, or are you in the middle? Are you going to be the tenant that has a subtenant? So just again, before we get into getting anything in writing, make sure right at the off you're doing it right. You can't have a sham tenancy agreement. So if you think you're protecting yourself by saying it's a license and it isn't a license, it's a sham. It will in law be held as a tenancy agreement if there is a landlord tenant situation. You can't just say what you want it to be. It has to in law be correct, and it will be interpreted in the right way. And so I've put it in bold there: set yourself up to win. Once you've answered these questions and you're getting your written agreement in place, make sure it's a good agreement. Make sure that it protects you as far as possible. So think about things that you want to be in that agreement, because it's essentially a contract and both parties are going to have signed it. So it's legally binding. So in terms of service, if you have need to serve notice on the tenant for whatever reason, maybe you want to increase the rent, or maybe you need to seek possession for whatever reason, what are you putting in that agreement as to what is valid service for the purposes of those notices? So they usually have hand delivery. It's always my preferred. If you can hand deliver, they can't deny they've got it. But equally, first class post, does it have to be signed for? Does it have to be recorded in some way? Is email sufficient? I'm increasingly seeing tenancy agreements now that are saying if you give us your email address, tenant, we're allowed to serve things on you in that way. So thinking about things like that. Another example, can you reclaim costs if you need to in the future? And what I mean by that is tenants long gone, you go into the property and it's an absolute state and it's going to cost you thousands to sort it out. Is there a mechanism within the contract? Not just that you can claim that debt from them, because of course in law you can, but as part of that debt claim, are you entitled to also claim the costs that you incur from the court fees if you have legal representation? Are you entitled contractually to claim those costs back? So if you do a Section 8 notice and you go in on rent arrears, for instance, and you have a possession claim, if your tenancy agreement has a clause within it that says that that the tenant agrees to pay your costs in the event of X, Y, and Z, then that can be brought to the judge's attention. And not only can you be getting possession plus judgment for the arrears, you can also potentially be getting your full costs. So it's just worth making sure that what you have in writing is good and protects you. Then, of course, we need to be thinking about the safety checks. As landlords, obviously, you're obligated to make sure that the property is safe. So we know about gas, electrics, EPC. If everything's in place and completed, then you're on the right page to start this new tenancy. Now, I've put there, how long is the tenancy period? As the law stands, as it is, with an assured short hold tenancy agreement, you can stipulate a fixed term period. It's normally 6 months, can be 12 months, no more than 3 years, otherwise it has to be signed as a deed. But generally speaking, we'll see terms of 6 months or 12 months, and then it becomes a rolling tenancy on a periodic basis. You may have seen the Renters' Rights Bill, which is going to come into law. They're suggesting spring, summer next year, which is further away than I'd originally thought it would be. But that's what Labour are suggesting is the likely timescale. You may have seen that with that, they're getting rid of short hold. So there's not going to be a tenancy period. Everything's going to be contractually rolling on a periodic basis, period being when rent's paid. So they're likely to be monthly tenancies. So at this stage, if you're entering into new tenancy agreements, you can absolutely put a period in for now, but going forward, it's not going to be relevant. Okay, so you've done everything we've just talked about. Everything's in place. Wonderful written tenancy agreement that ticks all the boxes, protects everybody. You're obviously both going to sign it. I've said there at number 3, get 2 copies, so that you have a copy of the signed tenancy yourself. I know there's a lot of e-signatures going on at the moment. That's fine. Make sure you have a signed copy of that tenancy, and provide everything else to the tenant. So the gas safety certificate, the EPC that's valid when the tenancy commences, current how to rent guide. You know, provide everything to them that you need to. And it's good practice. And I always recommend, and I've seen it actually within the body of the tenancy agreement, which is actually quite a clever way to do it, or a separate piece of paper, but get the tenant to sign, to confirm, I have received X, Y, and Z. There's my signature. This is the date on which I received it, because you're not going to get tripped up later on down the line when you say, well, I did give you that. And they say, I don't remember it, because then it's your word against theirs. Whereas if they've written and said, yes, I've got this, they can't then go back and say they've not had it. And then obviously, you're probably very aware that if you do take a deposit, it's got to be protected, and it's got to be protected within 30 days. And it's 30 days receipt. I should underline receipt. It's not when the tenancy starts, it's when that deposit is received. So if you receive the deposit a couple of days earlier than the tenancy commencement, you've got to protect it within 30 days of that date. If you receive it a couple of days into the tenancy, equally, that's when the time frame is. And of course, when you protect the deposit, you've also got to be providing that prescribed information. So make sure you're providing that to the tenant once you've received the deposit. I've seen it, and there's been some ambulance chasers, as I like to call them, who are trying to suggest that there's been breaches of tenancy deposit because, for instance, the lettings agent's been too keen and given the prescribed information before the deposit's been received. So just make sure that it's when that deposit's received that you want to be setting your 30-day timescale to get it protected and get that prescribed information out. And I've also said there,
that's something that I've seen as well, is the protection deposit of newer landlords. It seems to be getting tripped up by that. It's happening more recently. I think maybe tenants are starting to become more aware of it and seeing that as an opportunity to I don't know, get away with whatever they want to get away with. Just while I've got you kind of paused there, I did have a question come through regarding the changes with the Renters' Rights Bill. So the Renters Reform Bill that the Conservatives introduced just before they kind of lost the power. It's not too dissimilar from that, and I think one of the stipulations in the Renters Reform Bill was that the assured short hold tenancies that were being removed, there was going to be an exception. There was a special condition for student lets. So that they're traditionally in for 48 weeks or 52 weeks a year at a time. Is that coming through with the Renters' Rights Bill as well? Is there going to be a special condition? Are you aware of that?
There's been soundings about it. But at this stage, we've only got what's written down, and it's got to go through the process of back and forth between the houses, of amendments being suggested, of them either being defeated or going through. So I know that a lot of landlords of student lets are a bit worried because they've not been as robust as what was in the reform bill. The rights bill as it isn't currently as robust. We don't think it's going to go through like that. So it's just a case of keeping our ear to the ground and seeing what amendments are made to it.
And in a similar vein, when this does eventually go through, so spring, summer of next year, I think you said, is it the case that anyone in an AST, let's say it's 12 months and they'd signed it in January, did that immediately become a rolling AST, a month-to-month AST?
Yes, and what is different from the reform to the rights is originally the reform, because of course getting rid of assured short hold is the means to stop Section 21, because Section 21 notices can only apply to a short hold tenancy. So getting rid of short hold tenancies is how they're getting rid of Section 21. So what the reform bill was saying was, once it becomes a law, once it's enacted and becomes the Renters Reform Act, from then, any new tenancies will immediately start off without a fixed term. They'll be rolling from the off. But we're going to have a 6-month period within which people can get used to this idea, and anything that's currently ongoing will, within the 6 months, move over. What the Rights Act is doing, or the Rights Bill, I should say, is saying, no, as soon as this is law, that's it. Everything becomes rolling. There's no fixed terms. So landlords just need to think carefully, I guess, about why they might want to fix now, because of course, as soon as you fix, and we're going to come on to Section 21 notices, but if you're fixed, you can't serve Section 21 notice to expire during that fixed term. So landlords at this stage might be thinking, hang on a minute, we're talking what, 6 months off, say. If I put them in on a fixed 6 months now, I'm not going to be able to serve a Section 21 notice on them during that fixed term. And hey ho, Section 21's going. So I might actually be inadvertently stopping myself from doing a Section 21. So I would be advising landlords at this stage to probably steer away from fixed terms anyway, just because they might inadvertently be stopping themselves from Section 21 at this early stage. Yeah. Just quickly, bottom of this slide on deposit, because I don't properly touch on it again, but prohibited payment, you may be aware of it under the Tenant Fees Act 2019. What basically was said was landlords cannot charge tenants fees other than these, and there's a stipulated set of payments that tenants can be required to pay. Rent is of course one, a deposit is one, but they put caps on a deposit. So a deposit cannot be more than 5 weeks worth of the rent if the rent is under 50,000 a year, or 6 weeks if it's more. And obviously, if you're in a fixed term, well, if you're now in a statutory periodic, which was a fixed term before the Tenant Fees Act came into force, you're okay. But if you're taking deposits now or since 2019, you need to be making sure that there's not an element of a prohibited payment in it because the deposit is worth more than 5 weeks' rent. The reason for that is that can actually stop you serving a Section 21 notice. And I am seeing that an awful lot and having to question landlords on it, and they're having to return, £35. But the law is the law. That's what it states. It's black and white. And so landlords just need to make sure that they're protecting it, but then they're not taking too much as well. So this is all things to think about at the outset when we're starting this new tenancy. Okay, so moving on, periodic checks. These are sensible. I'm pretty sure 99% of landlords do this. unless there's an issue. So there's certain obligations that the landlord has to adhere to, matters of safety, such as your gas safety, your electrical, carbon monoxide, fire alarms, that kind of stuff. The landlord has to keep on top of. But equally, the landlord also wants to keep on top of what we've called matters of comfort. But it's basically assurance for the landlord that the tenant is doing what they're supposed to be doing, or not doing what they're not supposed to be doing in the property. So periodic checks are important from a legal point of view. They have to be done. Equally, from a procedural point of view, for assurance for the landlord that everything is okay in the property, assurance potentially for the tenant, because they can then speak with the landlord and say, oh, this radiator, keeps not working, or there's this issue with this window. Keeping on top of things early is advised by me. I think to be honest, it should be essential for landlords running their business. They should be making sure they're doing things on a periodic basis to keep on top of things. There's a couple of agents that I'm working with in Liverpool now. Liverpool has selective licensing, so pretty much every L postcode in Merseyside, they have to have a license as a landlord to rent out the property. So I'm increasingly seeing lettings agents who are managing portfolios. They have 3 monthly periodic checks to keep on top of stuff. Because first of all, they're making sure they're keeping the council happy. Second of all, they're making sure there's nothing going on in the property. And third, they are nipping in the bud any potential threat of an allegation of disrepair. Because if they're going to the property, they're checking everything with the tenant and they're saying to the tenant, are there any issues? No. Okay, let's just sign this off. Then on a 3 monthly basis, they can say, well, you didn't tell me at that time that there was an issue. This is a new issue you've told me about. I'm going to get it sorted within a reasonable time. So periodic checks, I advise, I think they're critical to managing properly. So just on that, what we need to just think back to what I said, what feels like ages ago, but it wasn't that long ago, was that the tenant has this right to quiet enjoyment of the property. So for your periodic checks, including the required gas safety check, what does it mean? First of all, it means you've got to give proper notice if you're accessing the property. Normally, your tenancy agreement will say what you're to do, and it's normally in writing, 24 hours. Whatever it says in that tenancy agreement, do it. Go over and above. If you know that if you've got a good relationship, you can obviously ring them and speak to them, send a WhatsApp, however you do it. Make sure you are giving them the notice. Access is going to be required to the property for the 3 monthly periodic check, or because the gas safety engineer is coming around. What you need to be aware of, because of this quiet enjoyment, in law, it looks silly written down, but you as landlord, as the owner of that freehold or that leasehold, those bricks and mortar belong to you, but you do not have the right to enter that property. You can't just go in. You can't just open the door and go in because of this right to quiet enjoyment. And actually, the tenant can say no. They can refuse you access. If they do refuse your access, the police aren't going to get involved. There are legal means to go forward if they're genuinely not allowing you access. Unfortunately, it normally ends up in possession proceedings if they're being that kind of tenant. But 9 times out of 10, tenants are happy to allow you in to do what you need to do to keep the property safe, etc. Just be aware that you don't have the right to go into that property. And equally, just a quick aside, I have landlords sometimes say the tenants change the locks. Great. That's their quiet enjoyment. As long as they either put the locks back as they were when they moved in, or give you, when they exit, keys for the new locks, then actually they're allowed to do that. Landlords can't change the locks unless they let the tenant know it's happening, have a reason for doing it, of course, and actually give the tenant access back to the property with new keys.
Does the tenant need to consent to that?
Consent to the change of locks?
Change of locks, yeah.
It may well contractually be in the tenancy agreement that they're not supposed to, but realistically speaking, the landlord's not going to achieve much by querying it because it's their home, as I've said. So yeah,
I mean the other way round. So if the landlord wishes to change it, so let's say that the tenant wants to change their locks, it's their right to do it. But for whatever reason, then they're not changing them to as good a quality a lock as was originally in there because they're going for a cheaper version. Is there consent required on both sides?
Not my understanding. I guess if there's something in the written tenancy agreement, then maybe so. But I don't think that the tenant has to have permission to change locks. I think if they do, they do. You know, it depends why they're changing the locks, doesn't it? It doesn't happen an awful lot, but you do. It does from time to time happen. And I just say to landlords, look, as long as when you get that property back, you're able to either get new keys, you're probably going to want to change the locks yourself anyway. But as long as they're going to leave, then I just wouldn't worry about it. It would make me think, hang on a minute, why they're changing the locks? That what they're trying to keep out or what they're trying to keep in. It does make the landlord start to be suspicious of the tenant. But yeah, it's just something to just be aware of, that this right to quiet enjoyment, it's enshrined, and it's not in law, but of course there is the Protection from Eviction Act 77. There is the Protection from Harassment Act 77. So even though the right to quiet enjoyment is not written anywhere in a law, it is through case law, just the common law now. It's what we follow, and the Protection from Eviction Act and the Protection from Harassment Act enshrine that by saying what landlords cannot do in relation to the tenant.
Just on that point, because Richard's added a good point here to say that it could be a potential insurance issue for the locks to get changed. And I want to pick up on something that Andrea said as well, which is, I guess, the paradox that you brought up of the landlord has these obligations to either enter the property or have tradespeople, for instance, enter the property, do inspections, make sure that the gas safety checks every single year, electrical checks, etc., etc., etc. So there are obligations on the landlord to actually go in and be able to do this. But conversely, the tenant needs to consent to entry to this property. So actually the landlord could end up being prosecuted for not having an updated gas safety check if the tenant were not to allow them in. So is there a point where it's to say, well, look, this needs to be done within the next month? What's your availability? Because it's not an option anymore. We need to have someone go in and perform a gas safety check on the property.
Yeah. So what I always say is evidence, evidence, evidence. Have stuff in writing. So if the gas safety check is due in 2 months' time, whatever your normal timetable is as a landlord, if the gas safety check's coming up for being due, you write out to the tenant and say it's due. We've arranged, and some landlords will say, can you let me know your availability? Or some landlords say the gas engineer is going to come on this date at this time. Is that okay? Let me know. If you're not getting a response, or if the gas engineer goes and they don't let them in, it's about following up in writing. You've not allowed this to go ahead. In law, it needs to be done. Can you please confirm your availability, or can you confirm that the gas engineer can come on this date? And it's about keeping written evidence. I cannot see how a landlord could be prosecuted if they have done all they possibly can to try and get that check done. So it's about just documenting, look, I'm trying, and they're just not letting me in. And of course, if you get into a point where they're not letting you in, it's normally at that point getting to a point where the relationship's probably broken down and the parties maybe need to think about bringing that tenancy to an end. But for self-protection, preservation, everything should be in writing. Obviously, it can be kept electronically on a computer. You don't need to keep reams and reams of papers in a filing cabinet, but everything in writing. Because as soon as there's something in writing, as soon as there's dates on things, there's signatures on things, it just makes them more credible. Just very quickly on this slide, I've put this in on periodic checks. It's not really periodic check, but I was just trying to think to slip it in. That something that's easy to forget is that the tenant has a right, and actually the landlord has an obligation in law to make sure that the tenant knows who their landlord is, how to get in touch with their landlord. And so maybe the business is changed if you have your portfolio through a business. Maybe you've purchased a property with a tenant in situ. Maybe the registered address of the the company or of you, you know, has changed, but you need to make sure that the tenant is kept up to date. So changes in the actual landlord themselves. So it's no longer Mr. Bloggs, it's now Miss Jones. That has to be notified to the tenant and it has to be in writing. There's no prescribed form. It's called a Section 3 notice because it's Section 3 of the Landlord Tenant Act 85. It's got to be done within 2 months. There's a fine attached to it. I have never in 14 years known of a landlord to be fined for not doing it. Equally, why would you not? Because you want that tenant, if you've taken over the property with them in situ, you want that tenant to know your bank details because you want them to start paying you the rent. So that's required. And generally speaking, the tenant is entitled to know, well, they need to know an address on which to serve things on the landlord, should they so wish. Quite often that can be the lettings agent's address, can be a company address. But again, that needs to be notified to the tenant. And that's Section 48 notice because it's Section 48 of the Landlord Tenant Act 87. So 2 completely different acts, but they're essentially achieving the same thing. They just have to be in writing. There's no prescribed form. I've seen NRLA versions of it. It's just a piece of paper and it just gives them the details they need to. We've written out to tenants before when the landlords come to us and we realise, you know, months down the line that they've not done that. And, you know, we just write out a letter and say, look, this is your new landlord. This, you know, these are the details. Just make sure you're on top of it because it can trip you up. And as I've said there, with a Section 48 notice, until they know where you are and what your details are, they can validly say, well, how am I supposed to pay rent? As soon as it's done, rent becomes payable and actually updated. But it's just to be aware of, because if I've never seen it, but I'm surprised I'm not seeing it because some duty solicitors are insane and they will throw kitchen sinks at things. But it wouldn't surprise me for a duty solicitor to say, have you served a Section 48 notice? Oh, if you've not, then those rent arrears aren't owed because they didn't know who you were, where you lived, etc. So just constantly being on top. It's all paperwork. It really is all paperwork, but just being on top of that, you know, just something to be aware of. Okay, so I'm going to move on to potential issues, and I answered my question there. There it is in pinky red. Why are all these points, especially on the new tenancy start, on the compliance, on the deposit, on the licensing, etc., why are they important? Well, the question I asked right at the outset was, who has the legal right to end residential tenancy? The answer is the tenant, of course. The other answer is the court. So a landlord can't bring that tenancy to an end unless the tenant consents, in which case they're surrendering it. It's between the parties. But if the tenant isn't willing to bring that residential tenancy to an end, even when they owe £1,000 worth of arrears, then the court needs to be involved. It's a set court process. And I don't like saying it, you know, I hope not. It's not unreasonable to think that in the future you might need at some point to invoke that process. Genuinely hope not, but it may well be the case. So bearing in mind that the tenant can bring it to an end, but if the landlord wants to bring it to an end and the tenant isn't willing, then we're looking at the court process, which, as you're probably all very aware of, is a 3-stage process. It's set out in the Housing Act 88, which, of course, the Renters' Rights Act is going to slightly kibosh by getting rid of Section 21. At this stage, the law is 3-step process, service of a notice under either Section 8 or Section 21. If that ends, court proceedings where you will seek an order for possession. When that order for possession is given, the third and final step, and quite often landlords don't realise this, I've got my order, why have I not gone? The court told them to go. Unfortunately, what Section 5 of the 88 Act says is that the landlord will lawfully gain possession when they obtain an order for possession and they execute it. Execution is via a bailiff. So that's when the bailiff comes knocking, and that's when actually it's lawfully done and the property is back in your possession. So as I've said, tenant eviction, there's 2 types, Section 21, Section 8. Section 21 known as no fault. I have to say that's a bit of a fallacy. 9 times out of 10, if I'm instructed on a Section 21 notice, there's an underlying reason. They can absolutely vary. They can be wanting to sell, or, you know, tenants just being a bit of a pain, realistically, but you're not going to get them through on a fault basis. You know, they keep being late on the payment of rent, but they keep it topped up just enough that you're not going to get anywhere on a Section 8. So Section 21 and Section 8, as I said. And so Section 8, it's usually when there's been some kind of breach, normally payment, you know, non-payment of rent or behaviour, breach of tenancy, that kind of stuff. And obviously I've just put a little asterisk on Section 21 because everybody's watching this space. The Renters' Rights Bill has been released. It is going through. Section 21 since, was it 2019? It's been on the table as going. It is going to go. There's no going back on it. But as no doubt a lot of you have read up on it, there are going to be new Section 8 grounds. So all is not lost. There is going to be a means to get rid of troublesome tenants if needed, or to get the property back because you want to move back in or sell or whatever. So Section 8 is going to be beefed up with Section 21 going. So Section 21 in a little bit more detail. Everything we've talked about, this is where they're important. Because basically, if you miss one of them, you're very likely to be serving an invalid Section 21 notice. So we've talked about gas safety. We've talked about the EPC, the how to rent guide. Has the deposit been protected? Has the prescribed information been given? If it requires a license, have you got it? Or if you haven't got it, have you applied for it? You need to be doing all these things. If any of these aren't in place when they should be, your notice is automatically invalid. And the problem is quite often, and actually I just on the deposit thing, I was talking earlier on about prohibited payment. Again, if your deposit is more than it should be, it trips you up. Your notice is invalid. So a lot of these can be corrected. So your gas safety certificate, as long as you had one that was valid when the tenancy commenced, you can provide it late. Same with your EPC. How to rent guide, you can provide a copy to them. The deposit, if it's not been protected, the only way to validly serve a Section 21 notice is to return it if you've not done it as you should in the 30 days. With the prescribed information, you can just provide that late. With your license, if you've not got it and you should have, apply for it, and then you're okay to go. The problem is landlords serve Section 21 notices and they didn't know about the how to rent guide, for instance. And then it expires 2 months later, they get to court, and then the judge says, your notice is invalid. Mm. It's either defended, in which case you might have to pay their legal costs, and it's more than likely going to be thrown out. So it's cost and it's time. So it's key to make sure that all those obligations are followed. And that's why I said, when you're setting up your tenancy agreement, get them to sign to confirm they've had the gas safety, they've had the EPC, they've had the how to rent guide, they've had the prescribed information, because they can't then say, I've not had it. Whenever we do a Section 21 notice, we actually re-comply, we call it. But what we will do is, before we serve the notice, we'll provide them all those documents. And we'll say, here they are, so that everything you've got is up to date. 2 days later, we'll then serve the notice on them. So there's no way that they can say that the landlord hasn't been compliant, and they can't query the validity of that notice.
I was just going to say, actually, that with that being said, that presumably anyone involved in this law worth their salt would have a checklist before serving a 21 of saying, look, has this been done, has that been done? Otherwise you're just wasting your time, and you know you're due for disappointment.
You would be surprised. I mean, genuinely, I had one last week, and they'd done their own notice, and they came to us to do the accelerated proceedings, and I said, you know, I really don't like to tell you this, lettings agent, but the notice that you've done on behalf of the landlord is invalid because there's a prohibited payment. Oh, yeah. We didn't know about that. Well, you know, you're a paid service, so you should. And loads do, most do. I get, you know, some instructions we get through lettings agents in particular, they're wonderful, because you know they've done everything and it's so simple and straightforward. But But it's worth landlords being aware of all of this, even if they're giving it to their lettings agents. It's just to know. And of course, we're going to come back to the Renters' Rights Act, aren't we? Because this is going. Now, interestingly, you're still going to have to get your gas safety certificates because it's required under the regulations. It's still going to have to be safe from an electrical point of view. The EPC, to be honest, if you want to sell it, you're going to have an EPC anyway. So you're still going to want these things, but they don't apply to a Section 8 notice. They're not being pushed over to a Section 8 notice. So these things that trip up on Section 21 aren't going to be as troublesome. Even a license, you should have a license. You get fined if you don't have a license, and you should, but that doesn't affect a Section 8 notice or the resultant claim. Deposit, yes, we'll come on to that. But most of this compliance headache is actually going to go. The new headache is that you're going to have to rely on different grounds instead of a Section 21 notice. So Section 8 fault evictions, normally contentious. Examples, as I've said, rent arrears, antisocial behaviour, damage to the property, general breach of tenancy, they're subletting without your consent, etc., etc. There's actually 17 grounds on which a Section 8 notice can be served. 8 of them are mandatory. The rest are what are called discretionary. On a routine basis, we use 4 of them because there really is not much point in serving a Section 8 notice. If you want that property back, Section 8 notice only has teeth when you're using a mandatory ground. So the mandatory grounds that we use, ground 8 on rent arrears, where there's at least 2 months worth of rent owing. With an 8, we would always put 10 and 11 because they're rent arrears grounds generally, but they are discretionary. The other mandatory ground we use, and we'll probably use in a lot more when the Renters' Rights Bill becomes an act, is ground 1, which is where landlord wants to move back into the property. That's actually being broadened, so it's not just landlord and partner or spouse, but it's going to be landlord plus landlord's family members. So if, for instance, child's returned from university and they need somewhere, child or parents, or so it's being widened, but that is mandatory. Other discretionary grounds, even if they're growing cannabis in the back bedroom, it's discretionary that they've breached their tenancy, that they're engaging in antisocial behaviour. Judges do not like giving possession if they do not have to. If they're not mandated to, they probably won't. Now, the claim doesn't entirely fail. You just won't get an outright order of possession. You'll get what's likely a suspended order. So it will be suspended on terms. And I made reference to cultivating cannabis in the back bedroom because way back when, in my younger years, and I was working with registered providers, they had that an awful lot. And we actually had a suspended possession order made that they had to comply with the tenancy. They had to pay the rent as and when due. And they actually allowed the landlord to have 3 unannounced visits per year. So they couldn't obviously hide away whatever they needed to hide away. They could turn up and say, let us come and have a look. But they didn't get the property back. So that's the thing. Now, if you do have a suspended order and they breach the terms, that is then the way to go for your warrant to get your bailiff to come and actually get the property back. But it's more time intensive and it's just more problematic. So where it's not a mandatory ground, we always say just be aware that you're probably not going to get this property back if that's what you're actually looking for. And as we've said there in the ready pink, if you want the property back and you're unsure how to go, then seek a bit of advice. Just ring up and just say, look, this is where we're at. And obviously it's not on the right on about slide 3 or 4 where we've got our usual fixed fees and and our special rates for you guys. Should have actually put at the top telephone call, email. If you've got a generic query, we're always happy to speak to people. We don't put the clock on. We'll speak. Don't get me wrong, we're not going to speak to you for an hour. We're not going to go through hundreds of documents. If, for instance, you've served a notice and the council have said your notice is invalid, you can get in touch and say, look, they've said it's invalid, and we have a quick look and say, well, yeah, it is because you've not given enough notice, or yeah, it is because, so, we're a service that is happy to speak to people and help landlords get things done properly, quickly, effectively. So just sticking on Section 8, you're probably aware that the notices on Section 8 are usually much quicker. Currently 2 weeks from service, so our lovely ground 8 for the rent arrears. Most of the discretionary, such as breach of tenancy, delayed payment in rent, antisocial behaviour straight away. But generally speaking, it's 2 weeks. Now, interestingly, you may have seen that the Renters' Rights Bill is mooting to put it up to 4 weeks. Only the rent stuff. And they are also suggesting 3 months arrears, not 2 months arrears. So we'll see where that gets to. That is slightly changing, but it is quicker than your usual 2 months Section 21 notice. Also with notices, they do lapse. And the point of a notice, I guess, what Parliament were thinking when they actually brought in these provisions was that hopefully that notice will prompt either the tenant to pay the rent arrears off, or the tenant to leave, if they can't afford it, or the tenant to behave, or whatever it is. It's designed to be the first step that hopefully is all that's needed. They're not usually the only step that's used, but that's the point of them. But they will lapse. If you don't do anything on that notice, it just falls away, so it lapses. So a Section 21 notice lapses after 6 months from when it's served. A Section 8 notice lapses 12 months. So actually, you've got a bit of time on a Section 8 notice to see if the tenant is going to start behaving, is going to start being more consistent with paying off the arrears, etc. But you have only got 12 months on it. Just there, we were talking about when I first started talking about potential issues, and I said it's a 3-step process. You notice, your court proceedings, your bailiff. That is always the process. The middle bit there, the court proceedings, are different for Section 21 and Section 8. And you may well be aware of it. So with a Section 21, you can use the accelerated process. It is slightly quicker. I think they're slightly misrepresenting it, calling it accelerated. It isn't the quickest, but it is quicker than a Section 8. And again, it depends whereabouts your property is. We do an awful lot of work in the Northwest, for instance. The courts are generally much quicker than I had a case down in the central London County Court. My goodness, I think it was a 5-month wait for a hearing. So depending on where you are, the court may be quicker or slower, but you're accelerated. It's all done on the papers. And it normally just goes through on that basis. Your Section 8 will always have court hearing listed, always. And under the civil procedure rules, that's like the court rules that set how things have to be done on a procedural basis. It should, the court hearing date, be between 4 and 8 weeks of when the claim is actually issued by the court. It's not always the case. With COVID, obviously they extended it. And since then, even though it's technically back as a procedural rule, the excuse of courts is that actually we're too busy to meet that deadline. And it is what it is. There's nothing that can be done about it. They are understaffed and they are overworked. So it is what it is. But there will always be that court hearing. So I'm just going to go back on that slide a minute, because with the court hearing, I think what it's worth noting, this isn't on the slides, but I'm just talking on my feet now. That hearing, if your tenant doesn't turn up, straightforward. You demonstrate with your claim and with the witness evidence that's accompanied it. Look, they owe these rent arrears. This notice is valid. The ground was made out when the notice was served. The ground is still made out at this date. You are therefore, you must, that's what it says in the Housing Act 88, the court must award an order of possession. So if the tenant doesn't turn up to query it, you're going to get your order as long as everything's done correctly. If the tenant turns up, 9 times out of 10, they'll be able to speak to a duty solicitor that's in a room at the court, again overworked because everybody wants to speak to them. So then your hearing ends up being delayed. They'll speak to the duty solicitor, and the duty solicitor, and I'm very cynical because I see this all the time, they are supposed to have the tenant's best interests at heart, but sometimes they will delay things just because they can. So they will always ask the tenant 2 questions. First of all, Was the deposit paid? If not, fine. If it was it protected? Did they give you the prescribed information? Oh, they didn't. All right, they're in breach of the Housing Act 2004. We'll counterclaim on that. They'll also ask about disrepair. They'll say, the radiator faulty, boiler on the blink, is there damp? You know, they'll ask those questions. And as soon as the tenant says, oh yeah, it's a little bit cold, even if, and I am being cynical, and I know this is being recorded, but even if it's the slightest little bit of mold, which actually they could just wipe away, it's just a condensation issue. As soon as they say, yeah, there's an element of disrepair, at that first hearing, a judge will not deal with it because it's a 15 to 30 minutes hearing top. And they don't have the evidence before them. So they'll list it for directions, which allows the tenant to go away and put in a formal defence. It delays things. It gets problematic. We're coming back to the Renters' Rights Act here. When that does come in, they've said they are not going to look in the court process. They think it works okay. They haven't asked lawyers. They haven't asked big lettings agents. The court is on its knees as it is, and that's dealing with the majority of Section 21 accelerated claims that are done by the judge sat at their desk. It's not done in a court session. Whereas when we're just on Section 8, everything's going to have a court hearing. Everything potentially, if the tenant is turning up, is going to be disputed, is going to be delayed. We just have to wait and see what happens with the Renters' Rights Bill becoming law. But it's just wary to be mindful of. And I've read articles on this, and I think the problem is it's going to actually make landlords more picky and more selective because they don't want to end up in a position where they are having to invoke the court if they can help it. So there's a lot here just to be mindful of. And so I guess, summing up everything we've looked at, these are the kinds of typical errors that we see made by landlords, by lettings agents. I'm going to be honest, I've seen it by some solicitors. These typical errors will result in an adverse outcome at court. Not serving enough notice, your case is thrown out. If you're not following what the law tells you to do, your case will be thrown out. If you don't provide the prescribed information on your deposit, thrown out. If you don't update the tenant with that Section 3 or that Section 48 notice, your claim is going to be thrown out. If you're not following the prescribed means in your tenancy agreement and they're denying that they've received it, thrown out. If you don't protect the deposit at all, you protect it late, not only is your claim likely to be thrown out on Section 21, but you could potentially see counterclaim. And that is, so the tenant can bring an outright claim if you've breached the deposit requirements. The tenant can also bring an outright claim if they're alleging disrepair. But what they can also do, if you're claiming possession, is essentially piggyback on the back of that claim by bringing a counterclaim. It delays things. It makes things more costly. It puts you at more risk. The reason that the duty solicitor asks about the deposit and asks about disrepair is because they can potentially put a counterclaim on. What's the point of a counterclaim? If they owe you £5,000 worth of rent arrears, they're well within the mandatory grounds. If they're going to counterclaim because you've not protected the deposit, and so they say you owe me £3,000, what will happen is that £3,000 is offset against the $5,000 they owe you. So what they're trying to do is defeat your claim in that way. The problem with counterclaims is they then start to say, well, my counterclaim's successful, you should pay my legal costs. It's a minefield. So if you're not making these typical errors, you're not facing these consequences. And so it's just really important to, from the outset, set yourself up to win, do everything that you possibly can to make everything follow through, be in writing, be clear evidence that you've done everything that you need to do to make sure you're not going to be hitting any of these typical errors. There's a lot there. The last one I just want to tidy up with is bringing the tenancy to an end. And I've said there, the easy bit. Generally it is, because if you've got a tenant who is in the area because they are a nurse on a contract near this hospital and their contract's come to an end and they're moving back home, they're just going to leave at the end of your tenancy. That's easy. So it might be done by consent. even if you get an order from the court and they leave and the bailiff's been and everything's sorted out, generally straightforward. But what if after they've gone, you realise there's unpaid utility bills, there's damage to the property that you weren't envisaging, they owe rent arrears because you've done Section 21 and they've not paid rent now for the last 3 months, and then they've gone. What if the tenant's personal belongings are still there, or some of them are still there? What if they've said they've gone, but their brother's there now? What if you're not sure whether or not they've left? You think they've left? These are all potential problems that can come up. Some have easy, straightforward answers. Unpaid utility bills, you should always be on top of your paperwork. So as soon as they've left, you should be taking the readings. So you should be able to evidence to the relevant utility provider, they were a tenant during this period, they owe you that. Damage to the property, did you have an inventory at the outset? Have you had a checkup after they've left? What does the tenancy agreement say? What were they obligated to do? Because if there's damage in the property and you can evidence that that's going to cost you money to sort out, and there's a contractual basis for you saying, here's a debt you owe me, you can go and seek that debt from them. The same with rent arrears. Of course, if they've done a flip and you don't know where they are, there are ways to trace them, etc. They can't always escape. Do 9 times out of 10, well, I will always say to a landlord, what you've got to think is, am I throwing good money after bad? They owe me £3,000 worth of rent arrears. I know they've not got a bean. So am I really going to spend another £300, £400 getting a CCJ against them, which I'm still not going to see that money for? So these are problems that you just got to be aware of. Tenants' personal belongings are an absolute bugbear. They are unreal. So the Act is from 1977. It's called the Torts Interference with Goods Act. It's really old, older than a lot of us. And basically, when the tenant has left belongings in your property, they're still their belongings. And so what you've got to do is give them reasonable amount of time to remove them. It's not defined, of course. Why would it be? Why make things easy for us? So it's reasonable, depends on what it is. You know, if it's a 4-poster bed, then it might take them a bit longer to remove it than if it's a microwave. If it's an old shoe, there's just one, that's clearly not something they're going to want. So you can use a degree of reasonableness and common sense. But if they do leave stuff, you should be reaching out. Strictly speaking, you should be serving what's colloquially called a torts notice. But equally, if you still have their details, you can just be emailing saying, look, you've left X, Y, and Z. Can you please come and get them by this date? If you don't, I presume you don't want them. Please let me know. You know, it's just about, again, getting everything evidence that you're trying your best by them, because what you don't want them to do is turn around and say, oh, you've gotten rid of my computer, my bed, my wardrobes, there's £3,000 worth of stuff there, you owe that to me. So protecting yourself, following what the law says, being reasonable with it. Where there's people left in the building, that will not happen if you've had a bailiff go, because the bailiff clears everyone out, whether they're a tenant or not. Everybody goes from the property. But if you've had a situation where tenants left and they've allowed their friend, their brother, whomever to go into the property, then even though they're not your tenant, they're still protected by the Protection from Eviction Act. So you need to be thinking about what's the most sensible, straightforward, cost-effective way to get them out. And then again, they've left, think. So this is abandonment. And people ask all the time, can I serve an abandonment notice? If you want to, it's not a legal document, it means nothing. So if you think they've left, protect yourself, because you don't want it to be a situation where you think they've gone, but it turns out they're in a coma for 3 months and they come back and say, whoa, hang on a minute, you've kicked me out of my house, you know, or they've gone on a long holiday. Yes, they should have let you know, but are they going to do? Maybe not. Common sense. If you think they've left, how do you evidence it? You know, is the rubbish in the bin, in the outside bins? What have the neighbours seen? If you look through the letterboxes, there a build-up of post. If you're ever concerned, you can let yourself into the property just to check that they're not there, you know, and unresponsive. So if you're ever worried in that way, let yourself in. If they're there, apologies, I was concerned for your welfare, I'm leaving. If they're not there, you know, there's the food in the fridge. Is the bedding on the bed? Is there a toothbrush in the bathroom? Obvious signs that somebody's definitely no longer there. But again, how do you evidence that? My advice is speak to the local authority and see what the position is on council tax. If they've done a flip, they don't want to be responsible for the council tax anymore. They'll let them know. They'll just not let you know that they've gone. So if they've informed council tax, oh, I'm no longer at that property, they'll confirm that in writing for you. That's as good as evidence as you're going to get that they're no longer there. If you're still having trouble with that, I'm increasingly seeing landlords asking us to trace, so we can go through a tracing agent to find, and they scour documents such as the electoral roll, mobile contracts, etc. Are they now registered at another address? It's not an assured short-hold tenancy if it's not their main property. So if they're registered elsewhere, you've got in writing from that tracing agent that that's no longer their property. So that's probably enough. But I think those last two, if there's people still in the building, if you're not sure, just seek a bit of advice. More than anything, check what your thought process is, because it's always nice to have someone say, yeah, that sounds sensible to me. But just protect yourself as far as you can. And so just summing up, as I've said, only the tenant or the court can lawfully bring that tenancy to an end. So do your homework, make sure you know everything you need to do, and make sure you're compliant. Keep your paperwork in order, because it might become gold. Set yourself up to win by making it easier from the outset, having everything in writing, having the tenancy agreement reflect terms that suit you. Have everything in place, have them sign what they need to sign, because they can't deny it if they've signed and dated it. Don't make silly mistakes that are definitely avoidable. If you do make a mistake, own it, get it corrected as quickly as you can, and then press on. If you're ever out of your depth, get help, whether that's, speaking to fellow landlords who've been there, done that, if that's speaking to a lettings agent, if that's speaking to a law firm, whatever it is. If you're out of your depth and you're not sure, then just get a bit of help. And you can reach out to us if needs be. That's all I have to say about that.
And now I must admit, I've been guilty of a slight dereliction of duty, because we've had quite a lot of questions come in, but what you were kind of delving into was so valuable that I thought I can't really jump in and get in the way again. No, that was absolutely brilliant, and yeah, one of the best webinars we've done in a long time in terms of just added value to the membership. So thank you for that. I'm going to jump over to some questions, because I know that we've had quite a few good ones come in. Some are quite specific, so we'll have to go back a little bit.
Okay.
Others a little bit more general, but we'll try and get as many done as we possibly can in the time we have. So going right back to the top of the presentation, Andrew asked, can you do a zero deposit protection?
What do you mean by zero deposit? If it's not a deposit, it doesn't need to be protected.
I assumed as much as well, but I thought perhaps there's something in that question that I'm not understanding, and Rebecca's going to grab hold of. So we'll leave it there for now. Andrew, if you want to reword that for us to make sure that we can understand, if it isn't talking about a zero deposit, then do let us know. We've got a question from Michaela, which is about the AST. So is it possible to put into the AST for the tenant not to make any changes to the property without prior permission? So this is in reference, I think we were talking about changing the locks at this point.
Right, okay. You'll normally see something of that ilk, of at least requiring consent to change the interior. Yeah, that's bog standard, that's absolutely fine. Of course, the problem is, it doesn't mean the tenant's going to abide by it. And so if they are breaching the tenancy, the landlord's then thinking, well, what am I actually going to do about it? If it's just the locks, I wouldn't be bothering. If they've done whole-scale redevelopment of the interior, then yeah, you might want to be thinking, well, how do I correct this? But yeah, the tenancy agreement is a contract that's agreed between the parties. And so especially if you've got an individual landlord and tenant, they're two individuals. There's no unfair contract terms can be alleged. So it's what the parties agree with each other. And if they both sign on the dotted line, then they've agreed to what it says. That obviously the law can sometimes get involved. So, for instance, you can't contract out of Section 11 of the Landlord Tenant Act 85, which is in relation to disrepair. You can't have interest at a rate of higher than 3% over base rate, because the Tenant Fees Act says that. But generally speaking, that contract can say whatever you want it to.
With regards to serving either documents or whatever it might be for the tenants, Steve's asked if WhatsApp is acceptable, or is it email only? And Richard has asked similarly. What he tends to do is email the tenants and ask for reply to confirm receipt. Is that sufficient proof of service?
If the tenancy agreement says you can serve by email, absolutely. If it's silent on email, but you get a response back from the tenant to say they've received it, then I can't see how they can deny it. So I think if they were to then seek to defend it, saying I didn't receive that notice, and you say, well, look, you've confirmed that you've got it, then I think they're on sticky grounds. I think that's okay. I always recommend, if ever we do a notice, or if ever landlords done the notice themselves and are just asking the question, I will always say, if ever possible, hand deliver it at the property. And I know, I obviously understand some landlords have portfolios, hundreds of miles away, so they're not going to do that. If they can't, fine. But if they're in the area, then absolutely, I have landlords who just have big portfolios where they live, and they will always go hand deliver, because they just cannot deny that. If you put it in the post, the tenancy agreement says, generally speaking, it's deemed served on you two days after it's been posted. Even if you say you've not received it, it's deemed served on you. That's a little bit more problematic, because Royal Mail aren't always as on the ball as perhaps they should be. And that's why I would generally say with tenancy agreements, if you can have service by email in it, and the tenant's willing to agree to it, then get it in there. Hand deliver if you can, email, everything. Hit all boxes, because you don't want them to say they've not received it, because that's critical.
I think it's interesting to hear you say that hand delivering is kind of the preferred method, because they can't deny it, because that's the one method where you're not going to have any documentation to say it was 100% delivered.
Not so. So again, if ever we do a notice, we will always complete a court form. It's the N215 certificate of service, and it's a really straightforward form. It's 2 pages. So on the second page, it actually tells you how you can work out when it's deemed served. So you can put something in the post, you can send it by email, you can hand deliver it, you can physically give it to them. And when you complete this form and you say when you did it and when it's deemed served, at the bottom it has a statement of truth, which is what a witness statement would have, or the claim form, or any court document. It has a statement of truth. So what you're doing is you're saying, it's like if you're in a courtroom and you affirm, or you swear on the Bible, this is the truth. And you sign it and you date it. The court won't question that, because if they do question it, you're in contempt of court. You can get sent to prison. So nobody's going to fill that document in if they haven't done as they've said they've done. So actually hand delivering and filling in the N215, because then when it comes to the court claim, either with your accelerated possession, you have B is the notice, B1 is your proof of delivery. I get a lot of lettings agents, they'll send me a Royal Mail postage. So that doesn't prove anything. They'll send me a photograph of them with an envelope in the door pointing at the door. Like, you could be posting
as good as you're going to get.
Well, you could post anthrax to them. Like, that doesn't show what you're doing. Whereas if you fill in that form, it says, what documents did you serve? Form 6A, section 21 notice, form guidance note. That's the address I served it at. That's how I served it, by hand delivering it at this time, signed at the bottom. Court will not go behind that. They genuinely won't, because If they go behind it, they're essentially saying that you're in contempt of court because you've lied in a court document and you're fined or you're imprisoned. So actually, that's why I say, if possible, hand delivery. You use an N215 certificate of service for postage as well. So you put it in the post, you tick the box that says by first class post. Interestingly, got to be first class. Don't put stuff in a second class post. I had an agent that had done just that, and I got in touch and I said, look, you've given lots of notice, you've given way over the 2 months notice, but has this tenant confirmed they've received the notice? Because if that tenant's not confirmed they've received the notice, it's not, under the court rules, it's not been properly served because you put it in the second class post. So just be mindful. It's got to be first class. I always say hand deliver it. And I literally hand delivered stuff myself. If it's been in the area and I've been on my way home, I'm like, well, I'll not spend £1.35. I might as well just go and pop it through. It's not a service we always do, but if it's in the area, I'll do it. It always terrifies me a little bit. I don't know why, going up to someone else's house and putting it through the letterbox. But you know, it's just the surest way. Email's great if as soon as you have them, because the problem is if they say they've not received it, it is incumbent on the landlord to prove that they've received it. And they'll say, well, you know, Royal Mail mustn't have served it. You know, and it gets difficult. Now, of course, a lot of tenancy agreements will say it's deemed served on you. We put it in the post, it's deemed served on you. But if you ever, I don't know if you've ever sent something by signed for first class, and then 2 days later you go on the tracker and they say, we'll let you know when we've tried to send it. That's not good enough.
Yeah.
You know, it genuinely, I had one actually. I had something that had to get to court, and it still said, a week later, we'll let you know. So I rang up the court. I said, I'm just checking. Have you received this? Oh, yeah, we received it yesterday. So Royal Mail just weren't updating the processes to let us know. But, you know, just be aware that service is as per your tenancy agreement. But if you are sending something by email and they're emailing you back to say, yes, I've received it, then that's absolutely enough because it's in writing.
Hughes added to that and said, for a very small cost, it's best to send everything of importance via something like DocuSign, which is a kind of signing software, online signing software, which also logs the date and the time that the tenant has opened it and signed it and all the rest of it. So that might be a digital version as well. So completely off that subject and onto well, it's not completely off the subject actually, but Anna just asked, can I use section 21 on an housing association who has let the property to tenants for the council? No.
No. I know there's loads of landlords thinking, I think I know the answer to this. You can only use a section 21 notice on an assured short-hold tenant. A social landlord cannot be an assured short-hold tenant because they're a company, they're not an individual.
Right.
So that is a rent-to-rent agreement. So the agreement between landlord and the housing association is a commercial agreement. It's just a bog standard contractual agreement between them. So you have to check what that says as to how you bring it to an end.
Catherine's asked, and they've got quite a few good questions in here from Catherine actually, so we'll be hearing more from her. But she says, if you've got an historic tenancy with more than 5 weeks deposit held, because I think it was 2019 where it all got changed, does the extra now need to be refunded? So let's say that they've done 6 weeks, do you need to refund that extra week?
No, it only applies if the deposit was, if the deposit was taken after the Tenant Fees Act came into force, because the minutiae, there's loads of different dates on the Shelter actually do a really useful note in it, but they can't, the way that they did the Tenant Fees Act was they brought it in like stages depending on the age of the tenancy. So my understanding is if the tenancy predated the Tenant Fees Act, you're okay to just leave it. Questionable if you then were to enter into a new fixed term, because you're essentially retaking that deposit and re-protecting it So at that stage, actually, there is an element of a prohibited payment there. But as long as it's on that old fixed term that's now become statutory periodic, that's never been reinstated at any point, then it should be okay.
Okay, lovely. I'm going to do, I think, 2 more because I've still got floods coming in. I think realistically, for the bulk of the questions, we're not going to be able to get through. I will send them over to Rebecca after the fact and see if we can get some of them answered. But equally, Rebecca, you did mention that members they've got your contact details there. It's worth having a conversation, and if it's something that members you feel that, or you may have made a mistake, you may have done something you weren't quite qualified to do, and you need some real legal advice. I think Rebecca's more than shown tonight that Landlord Support are there for the members to be able to help with this kind of thing. And also, I should mention that you're coming to the summits with us on Saturday. So for members on here tonight that are attending with us for our annual summit on Saturday, Rebecca will be there. We do have, and Laura, you might need to jump in and correct me, I think we've got 2 tickets left. So we're virtually sold out, but if you're not attending and desperately want to bend Rebecca's ear, then you've got a day's worth of opportunity there with 2 final tickets. So 2 final questions. I'm going to go back to Andrea's question earlier on because she did come back and clarify. I'm going to ignore someone's just put something in there at the end, but I won't say it out loud. So Andrea has said regarding the 0 deposit section, it's an insurance that the tenant pays each year rather than having a deposit which you hardly ever get back due to it being kind of in contention.
Is that done through some kind of agency, or how's that done? Because if that is just an agreement directly between the landlord and the tenant, then I think it might be on sticky ground. I would be thinking that might be considered a prohibited payment because as I said, under the Tenant Fees Act, it stipulates what is not prohibited. Anything that's not on that list is prohibited. And then what you don't want to be accused of is taking a deposit and not protecting it. So I think that might be something that I probably need to have a separate chat about.
And it's certainly something, once expanded on, it's something that I'd heard of before. I've never used anything like this myself, but I've heard of it more recently over the last year or 2 as being an option for, rather than taking a deposit, having this insurance instead.
So is the I have heard of different variants of it. So is it? I presume it's like it's an insurance scheme for the tenant, isn't it? So the landlord is never actually receiving anything from the tenant.
The tenant is paying the insurance scheme, and
yes,
should there be a problem, the kitchen gets smashed up, then the landlord is able to claim on that insurance on the tenant's behalf, I guess.
I think that is not a deposit. I don't think that's a deposit. I think that's a way. I think that's a way that, and I know a lot of local authorities are endorsing that because it's more reasonable for the tenant, but still offers a bit of protection for the landlord. So I'm going to suggest that probably isn't a deposit if it's done properly through a scheme.
And final question then, you're going to be very tempted here, I'm going to warn you, to ask a lot of specifics about how they got themselves in this situation. Now, we can go into that rabbit hole, but let's see if we can figure it out from the surface beforehand. So Richard has asked, if an EPC is expired and then was done after the fact, but the tenant was desperately wanting to move in, so the EPC was done a week after the tenant had moved in, can another AST be done to replace the original one so that everything's in order a month or 2 after they've been in the property?
Okay. I'm going to elaborate. I'm going to say no. The tenancy commences when the tenant moves in. So you don't actually have to have anything in writing for there to be a valid assured short-hold tenancy. If they're in there, they have occupation of the property and they are paying you a monthly amount of or a weekly amount of rent to be there, then there is an assured short-hold tenancy in place. You can't correct the fact that they're in there by having a signed tenancy agreement that says actually it starts on this day. because if the tenant says, well, no, I was in from that date, that is the date that the tenancy commenced. However, had it been guest safety, I would have been saying Section 21 off the cards. With the EPC, and again, and I'll caveat this with, it just depends on the judge on the day. Some judges are hard line and say, no, you have to have a valid EPC in place when the tenancy commences. Otherwise, you cannot serve a Section 21 notice. Other judges, so long as there's an EPC in place when the notice itself is served, are satisfied that that's enough. It's not written down, it's not specifically in Section 21A of the Housing Act, which talks about having to have the EPC. It doesn't stipulate, so it's open to interpretation. And there's not been a case that has got past the county court because nobody wants to spend money on taking it to the High Court and the Supreme Court, etc. So there's no hard line definition on whether the EPC has to be current when the tenancy commences or whether the EPC just has to be current when the notice is served. There's an element of risk, but it might be a risk worth taking. What you cannot do is seek to correct by having a new signed tenancy agreement, because you've always got to go back to when they first entered the property as opposed to when the tenancy is signed.
Yeah, that makes a lot of sense. Rebecca, we've got a shed loads of questions. Are you okay if I send these over to you tomorrow morning and you just cast your eye over them and see if there's any that stand out as particularly important for you to give a response to?
Yeah, absolutely. Yeah. If you just send them to the email address we've got set up.
I've got your email address. Yeah, it's fine. We don't need to organise the actual sending over now, but just wanted to get to make sure before I made that promise to the landlord. So, members, if you do have a question, you feel like you've been snubbed by me, I do apologise. We've had so much come through today, but we do need to get off at some point. So, thank you so much for a very valuable talk, an hour and a half worth of legal stuff. And you mentioned near the beginning, you said, I hope that you don't have to talk to me, because in most cases it's going to be talking to you in a when something wrong has happened. But I think with everything that you've mentioned today, talking to you has been incredibly valuable for our members. So really appreciate your time in coming on and kind of this consultative approach to starting a tenancy and ending a tenancy. The part you mentioned about who can end a tenancy, I'll give half marks to Cynthia, I think it was, who said the tenants. Now I was thinking in my head the tenant or the landlord, but of course the landlord's got to go through the court, so it's a new way of thinking about it that, you know, in context makes a lot of sense. I wouldn't say that everything that you've said is sensible, because simply the law is not sensible in every account, but the sensible thing to do is to kind of triple check every bit of criteria every way through and make sure you're not, you know, one toe over the line and done for. So that's it for tonight. Thank you all guys for coming along. Laura, we've got another lock-in scheduled for what month is it now?
We're in September.
So
next
for
month
the October lock-in.
That's on the 30th of October.
Really? Are you dressing up?
I don't have a witch's hat. I'll bring me 2 black hats though. So
okay, lovely. I'll see if I can get a pumpkin on my head or something. You'll also be pleased to know that it's my birthday between this webinar and that webinar, so that'll be my first birthday as first webinar as a 31-year-old. So who have we got on for that one?
A new partner, not yet launched, coming shortly, called Dakia.
Oh, it's Dakia.
It is Dakia.
Oh, great. Yeah, we won't mention anything more about those. They're coming along to the summit as well, but that is going to be a real big one for us. I was over the moon when we got those, because we've been asked about Velux windows for a long time, and they're not Velux windows, but you couldn't get much closer. That's all I'll give you. Thank you guys for joining us. We'll see you again next month. Don't be a stranger. Give us a call in the meantime. And of course, you've got all of Rebecca's details and Landlord Support's details as well, if you do have any more legal questions as well. All the best. See you soon.